Look, I'm just going to... obviously, the white paper was released on the 16th of April. We released the 2 draft planning bills. There's 400 pages of direct information on what the new planning system contains. And of course, there's a lot of other material that we've also provided that's available from the department's website. So, of necessity, it's going to be a potted highlights, and I'm sure you won't hold that against me. As the Minister said, it's very much trying to design a new planning system for the next 30 years, and with the challenges and constraints that Sydney and New South Wales face, that 1.3 million extra people, new jobs, the need for new houses as well. And it's consistent with the state plan approach, the New South Wales 2021. So all the ducks are aligned from a policy sense, and this was a key government commitment, as the Minister said, on their election. I won't repeat again. The Minister has given you an outline of how we've got to this point, at the risk of sounding like a MasterChef contestant. We are on the journey. This is not the end. The white paper is out for public comment up until the 28th of June, and certainly absolutely value your engagement here today, value your engagement at the community sessions that we're running, and also any submissions that you want to put forward to us. Look, obviously, with the Green Paper, we did get about 1,600 submissions there. We heard a range of views, and I've put all of those up on the screen. There are some other things that we heard very loudly and clearly from the Green Paper consultation that I might just go through, and that have led to us to make changes from the Green Paper into the White Paper and into the draft legislation. So the first one I want to concentrate on is people were concerned. They told us that there was too much of an economic focus in the Green Paper, and not enough focus on the environment, and not enough focus on social considerations. So the key object of the Act has been changed. The key object of the draft legislation is one of sustainable development that contains those 3 pillars of economic considerations, social considerations, and environmental considerations. And so we are proposing a system that can take into account all the broad range of issues, whether that be at the strategic planning stage or whether that's at a development assessment stage, so that in particular circumstances, if a particular proposal raises more environmental concerns, then those concerns can be considered paramount. If it's a social matter, those concerns can be considered paramount. But it's very much that sustainable development, that concept that was brought into place through the Brundtland Report in 1987 that we're focusing on, and that triple bottom line assessment. The other thing we heard very loudly and clearly was heritage. People were concerned that there wasn't very much a message in the Green Paper about heritage protection. Now, heritage, the conservation and adaptive reuse of heritage is also being put in place as a key objective of the draft legislation, and heritage will be preserved in this very similar way to how we do it now in the system. So we're not changing the Heritage Act, under which state significant heritage is administered. So that's completely not within the current proposals, and so that will remain. And items of state heritage significance will continue to be protected through the Heritage Act. In relation to local heritage and heritage conservation areas, they're currently protected through local environmental plans, and local environmental plans will be transitioned into the new system with their schedules of local heritage items, with their controls in relation to local heritage items, and with existing heritage conservation areas will all be transitioned into the new system in the local plans that I'll talk about a little bit later on. And in addition to that, the powers that are available to councils and to the Heritage Council in relation to items that are not currently listed in schedules for heritage, the interim heritage orders, they remain unchanged in the Heritage Act. If I might move on next to the building quality, particularly insofar as building design and aesthetics. Again, people were concerned in the Green Paper that we weren't, that didn't have a high prominence. Now it's been put in place as an object of the legislation, a key object of the legislation, focusing on good quality design from an urban design perspective, but also good quality building outcomes as well. Another area where people were concerned that the Green Paper didn't talk very much about was about the question of the health impacts of the planning system and the health impacts of planning decisions. So again, that's been introduced as a key object of the Act. Another area where people were concerned was strategic compatibility certificates. They've been wound back so that they're very much an interim measure, and they can't be brought into play until there's an independent report from a joint regional planning panel or a planning assessment commission. So I just wanted to outline that the proposals have changed quite greatly from the Green Paper, and we've been very keen to make that clear both in the White Paper and in the draft legislation. So in line with the Green Paper, we are still proposing grouping our changes under these 6 transformative areas there, and as the Minister's already mentioned, the community participation is really at the centre of the new proposals, but very much hand in hand with the new re-emphasis or new emphasis on strategic planning, and that's the heart of the major change of this system. One of the great difficulties with the current system, even though perhaps it could have been done under the current system, but it hasn't been done, is that there is often not a very good strategic context for making decisions. The work is not done up front, and people don't look at broad areas, whether it's regional, sub-regional, or even the local area, to try and plan for all the issues in an area, and then make it easier down the track to make decisions. Now, what we're proposing is clearly a situation where we want to redouble our efforts in that area, and we're mandating strategic planning by law for the first time. So that's in the draft legislation, and we have a number of levels of strategic planning. The key thing to remember about that is that the community will be involved up front in setting those decisions, in having those discussions, both at the regional and the sub-regional and at the local plan level. One of the interesting facts of our current situation is, if I can tell a little anecdote about someone who had this interaction with the current planning system. They found out one day that there was going to be a development application lodged across the street for a 4-storey residential flat building. They wondered how this could have happened. They went to the local council, and they found that 2 or 3 years before, the local council had rezoned the land across the street to allow for 4-storey residential flat building. They didn't get a notice in the paper. They didn't get a notice in the letterbox, although it was advertised in the paper. Now, the interesting thing about that, by way of an aside, was they actually found out their own property had been rezoned for 4-storey residential flat buildings. The system we're proposing says that you must have a much more engaged community at the time these strategic decisions about rezonings are made. It's no good not engaging the community up front when those key decisions are made. And the other proposal is that strategically all the issues that we talk about, that people are concerned about, the environment, housing, jobs, they can be resolved through a better strategic planning process involving the community. And that's the key message. This planning system that we're proposing requires us to work collaboratively with councils as our key partners and with the community. It won't work unless we all work collaboratively together during the strategic planning phase particularly. As I've said, we're mandating strategic planning in laws. That's a key difference from the current legislation, and we're proposing those 4 levels of strategic planning. For the very first time, we're trying to articulate in a very, very concise way what the state's interest is at that state level, some very plain English policies. All those strategic things are, in a bit of a hodgepodge in the current system. We're trying to get a very clear articulation of what the state's policies are in relation to land use planning, and they'll come down as those spatial layers are planned. And as I said before, the key change is that the community will be very much involved in doing those spatial layers at the regional, at the sub-regional, and at the local level. And so I said before about the local plan. Again, we're looking for a much better, if you can pardon the expression, a line of sight, so that people can see the strategic overview, how an area might grow and change, or how parts of an area might grow and other parts of an area might not change very much over time. And they'll have the planning controls directly related to that, and the more finer grained development controls also come down. And people can understand when they're determining an application more clearly what the strategic context for it is. At the moment, one of the great difficulties with the current system is that people go off and do the local plans, and after a number of years, that knowledge is lost to the council, and the DA planners are left without a proper context in which to make the decisions. What we're proposing here is a much clearer line of sight, plugged into strategic planning, telling the story about how an area is going to develop over time. We are proposing an additional assessment track. That's that code assessment track. We have exempt complying and we have a merit track at the moment. We are proposing an additional code assessment track as a key initiative in order to streamline a broader range of developments that are consistent with the strategic planning that's done up front. Interestingly, this is the pie chart which reflects the current New South Wales planning system. You'll see there in the most red parts of the pie, strawberry and raspberry, over 60% of all applications in the current planning system are either for houses, single houses, or alterations and additions to houses. And so currently we only have 23% of applications through complying development. When you look nationally, there's a bit of a disjunct because other key jurisdictions are able to do a much more broader range of development in their more streamlined development assessment tracks. So we are the odd person out there. We're proposing a range, and this is one of the great features, one of the great reasons I'm very happy to be here today, is we're proposing a range of development that might be suitable for code assessment. Code assessment, can I just say, is a decision that won't go to an accredited certifier, so it goes to a local council, and it will be determined by professional council staff, or it could be determined by the councillors, and it will be based on the controls that are put into the local plan through the planning controls and the development guides. So we're proposing a range of development there. Please, if you think any of that's not suitable, we're very happy to hear from you. We're very happy to hear as to why we should change the proposals. This is really very much up for discussion. But not everything will be code assessment, so please don't take that message home. There'll always be site-specific factors. So if it's environmentally sensitive land, it's very unlikely that code assessment will ever be the assessment track. It's also I can say, for example, having a pub or a hotel in a residential area will never be a code assessment decision. It would always be a merit decision if it was in fact not prohibited. So we're still retaining prohibitions so that they will still remain in the system. But please comment on the various proposals there. The other thing I might say before I completely depart from that is the other thing that you should remember is that 80% of all development applications have a construction cost of less than $290,000. So that's an interesting measure to gauge where we're looking at with code assessment. This is a big win for both industry and councils, and I also think for people that are local communities. We're moving to rationalise the state's part of the development assessment system. At the moment there are 14,000 referrals every year to state agencies, and so we're looking at reviewing what's out there. We're looking at trying to empower councils by giving back to them the sole responsibility for some of these referrals and concurrences. But where we can't, and we still need to retain expert advice from state agencies, we're looking at a more project management approach and a one-stop shop approach. Appeals and reviews. So very much the situation that you have now. If there's an appeal in the current system, you'll have an appeal in the new system. That stands for applicant merit appeals, objector merit appeals, and also for the provisions that allow a judicial review challenge that are in the current legislation. We're also proposing a slight expansion of the ability to get review of council decisions than currently exist now. We have also, finally, we've also worked with the Land Environment Corp to get a fast-track appeal system up and running. One of the biggest problems with the current system is that there are almost 70,000 development applications approved a year, and there are only 403 appeals. Now, the research that the court has done suggests that one of the big drivers to drive people away from court is the cost of appeals, and most of that cost is eaten up with lawyers and planning consultants. They've found that there's a direct relationship. If you can shorten the appeal period, come to a very crisp resolution of it, you can drive down the costs, and this is really an access to justice measure. We're also looking at, we've renovated the compliance and enforcement provisions of the Act, and because there's not been an increase in penalties for the last 14 years, we're looking at increasing the penalties and bringing them into line with penalties under similar legislation and other environment legislation there. So the maximum penalty now is only 1.1 million. Interestingly, there are a lot of comments about accreditation of environmental consultants to ensure that environmental consultants truthfully signed off EISs. We're continuing to look at the various accreditation models that are out there because some of them are very costly, and we're going to continue to work with stakeholders in this field. But we have proposed a new offence which is in line with what's in the current Commonwealth legislation, the EPBC Act, so that people that actually sign off knowingly or recklessly sign off an environmental impact statement that's not true will be subject to a penalty for the first time. As I said, building regulation and certification, there are a range of measures in there to actually try and improve the quality of buildings. We're looking at a broad range of measures to ensure that components of the building, both design components and actually the components of installation in key areas like fire safety, like wet areas, soundproofing, are properly installed, and so that we get better quality outcomes through that. We're also looking at, for more complex buildings, particularly for residential flat buildings, we're looking at a broader range of mandatory inspections than currently apply as well. Infrastructure, I haven't actually spoken about this very much, but this is a very key plank of the planning system. For the very first time, which is completely different to what we have now, is we are requiring infrastructure planning to take place as part of the strategic planning. And not only that, we're also requiring government agencies to be involved broadly in that strategic planning, and that will then feed in. So decisions that are made in a strategic planning exercise, where in a region or a sub-region we say, okay, this part of the sub-region might have additional housing and additional employment lands, but it needs key infrastructure to make that work, then if that's signed off across the whole range of, it will be signed off against the whole range of government, by the whole range of government, and then agencies will have to devote some of their work program, their budget funding, to provide infrastructure to support growth. And that's never been done before in any Australian jurisdiction. We know that we've not been particularly good in the past about that, but we are certainly embedding that for the first time in the strategic planning. And the other thing I will say about the strategic planning before I forget is that we're recommitting to a proper evidence base for strategic planning. So that we're recommitting to, you know, the issues that will ensure environment protection or biodiversity values or heritage, or the key issues about methodology for working out what the housing targets or what the job growth targets will be. So it's a recommitment to a more evidence-based approach right across the board. And as the Minister said, we're in the process of speaking to you. We've had almost, I think, over 2,500 people register for our various sessions, but the engagement will continue on. And there's a range of stakeholder groups. We'll be working with industry, with community, with environment groups, and with planners and academics to actually drill into further detail about the changes to the new planning system. So that will continue on. So while the submissions period will end on the 28th of June, we will continue working with all the groups during the implementation, the next phase, as we move towards introducing the legislation and finalising the legislation. So this is a key area. Please, your comments. We need your comments. We need to understand why you think certain things and why you think certain things are better. We're happy to have that discussion with you. This is the time to do it. Just as I said, we are on the journey, and the government's very, very keen for us to have this engagement here. We've you know, down the track. This is almost the end of the second year of the journey on the new planning system, but we're looking to introduce the new legislation next session. So again, this is an opportunity for everybody to have their say. So thanks very much.